the moment I saw the bright orange violation notice taped to my front door. I knew my day was about to turn sideways, but I never could have predicted the absolute circus that was about to unfold in my quiet neighborhood in Springfield, Illinois. I ripped the notice off the door and squinted at the tiny print. According to the document, I was being fined $300 for improper and hazardous electrical equipment visible from the street, specifically multiple extension cords connected to a portable generator unit. The notice was signed by Margaret Pemberton, the president of our HOA, dated just 2 hours earlier. My name is Isaac Vaughn, and I had lived in the Meadowbrook Hills subdivision for exactly 8 months. The neighborhood was one of those picture-perfect developments with identical lawns, regulation mailboxes, and houses that all looked like they came from the same catalog. I had moved here for work, taking a job as a software engineer at a local tech startup. The house was affordable, the commute was reasonable, and everything seemed fine until about 3 months in when I realized the HOA had more rules than the entire United States Constitution. I walked back into my garage where my generator sat, silent and still. The extension cords in question were neatly coiled beside it, all high-grade, outdoor-rated cables that I had specifically purchased after researching the exact specifications I needed. We had experienced a power outage the previous week that lasted 14 hours, and my generator had kept my refrigerator, a few lights, and my home office equipment running smoothly. The cords were visible from the street only because they ran from my garage to my house's electrical panel, exactly as they were supposed to. I grabbed my phone and called my buddy Derek, who happened to be a licensed electrician. He had actually helped me set up the whole system when I first bought the generator. "Derek, it's Isaac. I need a favor." "What's up, man?" "The HOA just slapped me with a $300 fine for my generator setup. Can you come take a look and maybe write something up that says everything is up to code?" Derek let out a low whistle. "Your HOA sounds like a nightmare." "Yeah, I can swing by after lunch." "I know that setup is solid because I helped you with it, but I'll bring my credentials and we can document everything." "Thanks, I owe you one." "You owe me several at this point, but who's counting?" While I waited for Derek, I decided to do some research. I pulled out the HOA bylaws, that thick packet of papers I had skimmed and signed when I bought the house. I spent the next hour reading through sections about exterior modifications, maintenance requirements, and architectural guidelines. There was a section about generators, but it was vague. It said that generators needed to be properly installed and maintained according to local building codes and regulations. It said nothing about extension cords being prohibited. I made myself a sandwich and was halfway through eating it when Derek's truck pulled into my driveway. He got out carrying a clipboard and a large toolbox, looking every bit the professional electrician in his work shirt with his company logo embroidered on the pocket. "All right, let's see what we're dealing with," Derek said, walking straight to my garage. He spent the next 30 minutes examining every single component of my setup. He checked the generator's specifications, measured the gauge of each extension cord, tested the connections, and took photographs of everything. Finally, he stood up and dusted off his knees. "Isaac, I'm going to write this up officially, but I can tell you right now that every single thing here is not only up to code, but it's actually better than what most people use. These extension cords are all 12 gauge, outdoor rated, and properly grounded. The generator is the right size for your needs. Everything is exactly as it should be." That's what I thought, but I needed to hear it from you officially. Derek pulled out a form from his clipboard and started writing. I'm going to document the make and model of each cord, their ratings, and my professional opinion that this setup meets all electrical safety standards. I'll include my license number and everything. This should be more than enough to fight that fine. You're a lifesaver. Just doing my job. But seriously, your HOA president sounds like she needs a hobby. After Derek left, I scanned his documentation and composed an email to the HOA board. I attached Derek's professional assessment and politely, but firmly stated that I would not be paying the fine as my equipment was properly rated and installed according to all relevant codes and regulations. I kept the tone professional, cited the specific HOA bylaws that mentioned compliance with building codes, and requested a hearing if the board still insisted on the fine. I hit send and tried to put it out of my mind for the rest of the day. The response came faster than I expected. At 7:30 that evening, my phone rang. The caller ID showed a number I did not recognize. "Hello, Mr. Vaughn, this is Margaret Pemberton, HOA president." Her voice was clipped and cold. "I received your email, and I'm calling to inform you that the fine stands regardless of what your electrician friend says. Derek isn't my friend in this context. He's a licensed professional electrician, and his assessment clearly shows that everything is up to code. The HOA board determines what is and isn't acceptable in this neighborhood, not some electrician. The extension cords are unsightly and represent a liability concern." I took a deep breath, trying to keep my cool. "Margaret, the bylaws state that generators need to comply with local building codes. My setup does exactly that. The cords are only visible when the generator is in use, which is rare. We've had one power outage since I moved in. The aesthetics of this neighborhood are my responsibility, Mr. Vaughn. We have standards to maintain. The fine will be added to your HOA dues if not paid within 10 days. Then I'm requesting a formal hearing in front of the full board, which is my right according to Section 12 of the bylaws." There was a pause. "Fine. The next board meeting is Thursday at 7 in the evening at the community center. You'll have 10 minutes to present your case." "I'll be there." She hung up without saying goodbye. Thursday could not come fast enough. I spent the intervening days gathering more evidence. I printed out the electrical code regulations from our county's building department website. I got written statements from two of my neighbors, Bill and Sandra, who said they had no problem with my generator setup and had barely noticed it. I created a presentation with photos showing that my setup was actually less visible than several other homes in the neighborhood that had various outdoor equipment. Thursday evening, I arrived at the community center 15 minutes early. The building was a small brick structure at the entrance to our subdivision, mainly used for HOA meetings and the occasional neighborhood event. Inside, a folding table was set up at the front of the room with 5 chairs behind it. About a dozen other residents were scattered in the audience chairs. Margaret Pemberton sat in the center chair, flanked by 4 other board members. She was exactly what I had pictured. A woman in her late 40s with an aggressively styled blonde bob, wearing a blazer that looked like it cost more than my monthly car payment. She had that particular expression that suggested she was perpetually smelling something unpleasant. The other board members were a mixed group. To Margaret's right sat Robert Chen, a quiet man in his 60s who I had met once at a neighborhood barbecue. Next to him was Jennifer Collins, a woman in her 30s with kind eyes who always waved when I saw her jogging. On Margaret's left were Todd Murphy, a stern-looking man with gray hair, and Linda Martinez, an older woman who was studying some papers in front of her. Margaret called the meeting to order at exactly 7. There were several items on the agenda before mine, including a discussion about updating the pool rules and a complaint about someone's trash cans being visible from the street. I sat through it all, my folder of evidence growing damp in my nervous hands. Finally, Margaret cleared her throat. Next item: violation appeal from Isaac Vaughn regarding generator extension cords. Mr. Vaughn, you have 10 minutes. I stood and walked to the front of the room, trying to project more confidence than I felt. Thank you. I'm here to appeal the $300 fine I received for my generator setup. I believe this fine is unjustified for several reasons. I launched into my presentation, methodically going through each point. I showed Derek's professional assessment, explaining his credentials and the specific ratings of each cord. I referenced the county electrical codes and showed how my setup exceeded the minimum requirements. I displayed the relevant HOA bylaw section and argued that I was in full compliance. I even showed the photos demonstrating that my equipment was less visible than various items at other homes. Margaret interrupted me several times with questions that felt more like accusations, but I kept my responses calm and factual. When I finished, I felt like I had made a solid case. "Thank you, Mr. Vaughn," Margaret said, her tone suggesting she was anything but thankful. "The board will now discuss and vote." I returned to my seat while the board members huddled together, speaking in low voices. I could see Jennifer and Linda nodding occasionally, while Todd seemed to be agreeing with whatever Margaret was saying. Robert remained expressionless. After about 5 minutes, they broke apart. Margaret looked at me with what I can only describe as vindictive satisfaction. "The board has voted. 3 members believe the fine should stand. 2 voted to dismiss it. The fine remains in effect." "On what grounds?" I asked, trying to keep my voice level. "I've demonstrated that everything is properly rated and up to code. The grounds are that the board has determined your setup to be aesthetically unacceptable and a potential liability to the neighborhood, regardless of its technical specifications. You have 10 days to pay." Jennifer spoke up, her voice tentative. "I just want to note for the record that I voted to dismiss the fine. I think Mr. Vaughn has clearly shown that his equipment is safe and properly installed." "Your dissent is noted," Margaret said sharply. "This matter is closed. Next item on the agenda." I walked out of that community center feeling a mixture of anger and disbelief. The board had essentially ignored all evidence and logic to uphold a fine that had no legitimate basis. As I sat in my car, I pulled out my phone and started researching HOA law in Illinois. What I found was both encouraging and daunting. Illinois had specific laws governing HOAs, and homeowners did have rights. However, fighting an HOA typically required either going through mediation or filing a lawsuit, both of which could be expensive and time-consuming. I could hire a lawyer, but the cost would probably exceed the fine itself. But this was not about the money anymore. It was about the principle. Margaret Pemberton was abusing her authority, and I was not going to let it slide. The next morning, I called an attorney who specialized in HOA disputes. Her name was Patricia Stevens, and she came highly recommended from several online reviews. "Mr. Vaughn, I've dealt with cases like this before," Patricia said during our phone consultation. "The problem is that HOAs often have broad authority to make aesthetic judgments, even when those judgments seem arbitrary. But she's ignoring evidence from a licensed electrician and the actual bylaws. I understand your frustration. Here's what I recommend. First, send a formal letter to the board citing the specific bylaw provisions and demanding they provide written justification for how your setup violates any actual rule. Make it clear that you're prepared to take legal action if necessary. Sometimes, That's enough to make them back down. And if it doesn't work, then we can file suit. But I'm going to be honest with you, it could cost several $1,000s in legal fees, and there's no guarantee we'd win. Judges often defer to HOA board decisions unless there's clear evidence of discrimination or violation of state law. I thanked Patricia and decided to follow her advice about the letter first. I spent that afternoon crafting a carefully worded demand letter. I cited specific Illinois statutes about HOA governance, referenced the bylaws, and demanded that the board provide explicit written justification for the fine within 7 days. I sent it via certified mail, so I would have proof of delivery. 3 days later, I got my answer, but not in the form I expected. I came home from work to find another violation notice on my door. This one was for failure to maintain lawn to community standards. According to the notice, my grass was 1/4 inch too tall and had some weeds near the mailbox. The fine was $200. I stared at the notice in disbelief. My lawn looked identical to every other lawn on the street. I had it professionally serviced every 2 weeks. This was clearly retaliation. I took dozens of photos of my lawn and my neighbors' lawns. Several had grass that was visibly longer than mine. Some had dandelions and other weeds scattered throughout. But apparently, only my lawn was a problem. That evening, I sent Patricia Stevens the new violation notice along with my photos. She called me back within the hour. "This is harassment, Mr. Vaughn. They're retaliating against you for challenging the first fine. I think we have grounds for a lawsuit now." What would that involve? We would file in civil court, arguing that the HOA is acting in bad faith and targeting you specifically. We'd seek to have both fines dismissed and potentially get an injunction preventing them from further harassment. With the evidence you've gathered, I think we have a decent case. How much are we talking? My retainer is $1,500, and the total cost would likely be between $3,000 and $5,000 depending on how much the HOA fights it. I did the math in my head. I was looking at $500 in fines so far, and if Margaret kept this up, there would be more. Plus, I could not just let her get away with this. Let's do it. Over the next week, Patricia prepared the lawsuit. She was thorough, documenting everything from my initial setup to Derek's assessment to the board meeting to the retaliatory second fine. She included the photos showing that other homes had similar or worse lawn conditions. She cited Illinois case law about HOA boards acting in good faith and following their own bylaws. We filed the lawsuit in Sangamon County Circuit Court on a Monday morning. By Tuesday afternoon, Margaret Pemberton was calling my phone nonstop. I did not answer, instead forwarding her calls to Patricia. On Wednesday, I received an email from Jennifer Collins, the board member who had voted to dismiss my fine. "Mr. Vaughn, I wanted to reach out privately to let you know that I support your lawsuit. Margaret has been running this board like her personal fiefdom for too long. Several of us have tried to push back, but she always gets Todd and usually Robert to vote with her. I've been documenting some concerning behavior from her over the past year. If it would help your case, I'd be willing to share what I have." I forwarded the email to Patricia immediately. She called Jennifer and scheduled a meeting. What Jennifer revealed was eye-opening. Apparently, Margaret had been systematically targeting homeowners she did not like for various petty violations, while ignoring identical issues with her friends' properties. She had approved a major home renovation for her next-door neighbor that clearly violated the architectural guidelines, but denied similar requests from others. She had used HOA funds to pay for a professional landscaping service for the community center, but had hired her brother-in-law's company without getting competitive bids. likely violating the HOA's own financial procedures. Jennifer had been keeping records of all of this, hoping that eventually enough board members would turn against Margaret to vote her out. But Margaret had a loyal faction and was skilled at political maneuvering. Patricia was thrilled with this information. This changes everything. We're not just dealing with a bad decision anymore. This is a pattern of abuse of authority. I'm going to amend our complaint to include these additional issues. The amended lawsuit was filed, and suddenly our case was about more than just my generator cords. It was about Margaret's entire tenure as HOA president. The HOA's response was swift and aggressive. They hired a law firm from Chicago, and their attorneys filed a motion to dismiss the case, arguing that the courts should not interfere with HOA governance decisions. We had to file a response, which meant more legal work and more billable hours. The first court hearing was scheduled for 3 weeks after we filed the amended complaint. I took the day off work and met Patricia at the courthouse. The HOA's attorneys were there, 2 men in expensive suits who looked like they litigated for a living. Margaret sat behind them, her face tight with anger. The judge was a woman in her 50s named Carolyn Walsh. She listened patiently as both sides presented their arguments. The HOA's attorneys argued that the board had broad discretion to make decisions about community standards, and that my lawsuit was an attempt to undermine that authority. Patricia countered that the board had violated its own bylaws, acted in bad faith, and specifically targeted me in retaliation for challenging them. Judge Walsh asked several pointed questions about the lawn violation and the timing of it. The HOA's attorney struggled to explain why my lawn specifically had been cited when the photos clearly showed other lawns in similar or worse condition. "I'm not going to dismiss this case," Judge Walsh finally said. "There are factual questions here that need to be resolved. We're going to proceed with discovery, and I'm setting a trial date for 3 months from now. In the meantime, I'm issuing a temporary injunction preventing the HOA from issuing any new violations to Mr. Vaughn, unless they can document that identical violations at other properties are also being cited." It was not a complete victory, but it was a start. Margaret looked furious as she left the courtroom. The discovery process was revealing. Patricia subpoenaed HOA records going back 3 years, including all violation notices, board meeting minutes, and financial records. What we found was worse than Jennifer had described. Margaret had issued 47 violation notices in the past year alone, but 32 of them were to just 8 homeowners. Meanwhile, there were numerous documented violations visible in photos from other properties that had never been cited. The pattern was clear. Margaret used violations as a weapon against people she did not like. The financial records were even more interesting. Margaret had approved payments to her brother-in-law's landscaping company, totaling over $20,000 over 2 years, all without competitive bidding. She had also reimbursed herself for various HOA-related expenses that seemed questionable at best, including several restaurant meals that she claimed were board business, but for which there were no other board members listed as attendees. Patricia scheduled depositions for Margaret and the other board members. I sat in on Margaret's deposition, and it was a thing of beauty. Patricia was polite but relentless, walking Margaret through every questionable decision, every selective enforcement, every suspicious expense. Margaret tried to maintain her imperious attitude, but as the questioning went on, she became flustered and defensive. When Patricia asked her to explain why my lawn had been cited when there were photos of other lawns in worse condition, Margaret's response was telling. "I can't be expected to personally inspect every lawn in the neighborhood. I was driving by Mr. Vaughn's house and noticed the condition of his lawn. And you just happened to be driving by his house 3 days after he sent a demand letter challenging the generator fine. That's a coincidence. Is it also a coincidence that in the 3 months prior to the generator violation, Mr. Vaughn had never received any notices, but in the 2 weeks after challenging that violation, he received 2? I have no control over when violations occur. But you do have control over when violations are noticed and cited, correct? Margaret's attorney objected, but the point was made. The depositions of the other board members were equally useful. Todd, Margaret's ally, admitted under questioning that he had not personally inspected my lawn before voting to uphold the fine. Robert admitted that he typically just went along with whatever Margaret recommended because he did not want the conflict. Jennifer was a great witness for our side, clearly articulating how Margaret had created a culture of fear and intimidation on the board. As we got closer to trial, the HOA's attorneys started making settlement overtures. They offered to dismiss both fines if I would drop the lawsuit. Patricia advised me to reject it. They're scared. We have them dead to rights on the selective enforcement, and those financial irregularities are serious. Push for more. We countered with a demand that the fines be dismissed, that I be reimbursed for all my legal fees, that Margaret resign as president, and that the board adopt specific policies to prevent selective enforcement in the future. The HOA rejected it. 2 weeks before trial, something unexpected happened. I got a call from Robert Chen, the board member who typically went along with Margaret. "Mr. Vaughn, I need to talk to you. Can we meet somewhere privately?" We met at a coffee shop outside the neighborhood. Robert looked nervous, constantly glancing around as if worried someone would see us. "I need to tell you something, and I need you to promise it won't come back to me directly," he said. "I can't promise that if you're about to tell me something relevant to the lawsuit, but I'll do my best to protect you as a source." Robert took a deep breath. Margaret has been forging signatures on HOA documents. About 6 months ago, she wanted to approve a special assessment to repave the community center parking lot. Linda and I voted against it because the cost seemed inflated. The vote failed, 3-2. But then the assessment went through anyway, and the meeting minutes showed that I had voted in favor. My signature was on the approval document, but I never signed it. Do you have proof? I started keeping my own notes after that, documenting the actual votes versus what appeared in the official minutes. There are 3 instances where the official record doesn't match what actually happened. Why are you telling me this now? Because I'm tired of being complicit. I let Margaret intimidate me into going along with things I knew were wrong. But watching her go after you so vindictively made me realize that someone needs to stand up to her, and I think she's about to do something desperate. What do you mean? She's been talking about using HOA funds to hire a private investigator to dig up dirt on you. She wants to discredit you before trial. I think she's panicking because she knows the financial records are going to come out. I immediately called Patricia and told her everything. She was thrilled with the information about the forged signatures, but concerned about Margaret's plans. If she uses HOA funds to hire a private investigator to target you personally, that's another abuse of authority. But we need to be prepared for whatever they might find or fabricate. There's nothing to find. I'm the most boring person alive. I go to work, come home, play video games, and occasionally grab beers with friends. Good, let's stay vigilant. The following week, I noticed a car parked across from my house at odd hours. I took photos of the license plate and sent them to Patricia. She ran the plate and confirmed it was registered to a private investigation firm in Springfield. Patricia filed an emergency motion with the court, presenting Robert's information about Margaret's plans to use HOA funds for a private investigator. Judge Walsh was not pleased. She ordered the HOA to produce all financial records from the past 6 months and scheduled a hearing. At the hearing, the HOA's attorneys tried to argue that hiring an investigator was a reasonable expense to defend against the lawsuit, but Judge Walsh was having none of it. The HOA is a nonprofit organization funded by mandatory homeowner dues, she said. Those funds are meant to maintain common areas and enforce community standards, not to conduct opposition research on individual homeowners. Unless you can show me specific evidence that Mr. Vaughn has committed some violation that requires investigation, this looks like harassment. The HOA's attorney could not provide such evidence. Judge Walsh ordered the HOA to cease using any funds for investigation of me personally, and warned that further violations could result in sanctions. That was apparently the breaking point. 2 days after the hearing, I received an email from Linda Martinez, another board member. Mr. Vaughn, I want you to know that Jennifer, Robert, and I have called a special meeting of the HOA board. We have the votes to remove Margaret as president. The meeting is tonight. I thought you should know. I asked if I could attend, and Linda said the meeting was open to all homeowners. I drove to the community center that evening and found about 30 people in attendance, far more than the usual board meeting. Word had clearly gotten around that something significant was happening. Margaret sat at the head table, looking defiant. Jennifer, Linda, and Robert sat together on one side, while Todd sat next to Margaret. The tension in the room was palpable. Linda, as vice president, called the meeting to order. We're here tonight to address serious concerns about the conduct of our HOA president, Margaret Pemberton. A motion has been made to remove her from the position of president for cause. Margaret tried to interrupt, but Linda held up her hand. You'll have a chance to speak, Margaret, but first, we're going to present the evidence. For the next hour, the 3 board members laid out everything. The selective enforcement of violations, the financial irregularities, the forged signatures on official documents, the use of HOA funds to hire a private investigator against a homeowner. They had documents, photos, and testimony. It was damning. Several homeowners in the audience spoke up, sharing their own experiences with Margaret's selective enforcement and vindictive behavior. One man described how Margaret had fined him repeatedly for having his boat visible in his driveway, despite the bylaws allowing boats to be stored on property for up to 48 hours, and he had never exceeded that time limit. A woman talked about how Margaret had rejected her architectural request to paint her front door a slightly different shade of blue, then approved an identical request from Margaret's friend 2 months later. When it was Margaret's turn to speak, she was visibly shaking with rage. This is a witch hunt orchestrated by Mr. Vaughn and his lawsuit. You're all being manipulated. The evidence speaks for itself, Margaret, Linda said quietly. You've abused your authority, violated our bylaws, and possibly committed fraud by forging signatures. We have no choice but to remove you. The vote was taken. 3 in favor of removal, 1 against Todd, and 1 abstention. Margaret was not allowed to vote on her own removal. Margaret Pemberton was no longer HOA president. She stood up, grabbed her purse, and stormed out without another word. Todd followed her, leaving the remaining 3 board members to begin the process of cleaning up the mess. The lawsuit was settled 2 weeks later. The HOA agreed to dismiss both fines, reimburse me for all legal fees, and implement new policies to prevent selective enforcement. They also agreed to hire an independent auditor to review the HOA's finances, and recommend any necessary actions regarding the questionable expenses during Margaret's tenure. The audit revealed more problems. The payments to Margaret's brother-in-law's company were clearly inflated compared to market rates for similar services. The reimbursements to Margaret for personal expenses totaled over $3,000 that she could not adequately justify. The board voted to demand repayment from Margaret, and when she refused, they filed a civil suit against her. But it got worse for Margaret. The forged signatures on official HOA documents caught the attention of the state's attorney's office. Forgery is a crime in Illinois, and when Robert provided his documentation showing that official HOA records had been altered to change vote outcomes, prosecutors took interest. I was contacted by an assistant state's attorney named James Morrison, who asked me to provide all the documentation from my lawsuit. I gave him everything, including the depositions and the financial records. 6 weeks after Margaret was removed as HOA president, she was arrested and charged with forgery and theft. The forgery charges related to the altered meeting minutes and signatures. The theft charges related to her misuse of HOA funds for personal expenses and overpayment to her brother-in-law's company. I was not present for the arrest, but Jennifer called me with the news. The police came to her house this morning. Apparently, there were more forged documents than even we knew about. She had been altering records for almost 2 years. The criminal case moved forward over the following months. Margaret hired a criminal defense attorney, but the evidence against her was substantial. The prosecution had documents with forged signatures, witnesses who testified that votes had been misrepresented, and clear financial records showing misappropriation of funds. I had to testify at a preliminary hearing, explaining the timeline of events that led to my lawsuit and the subsequent discovery of Margaret's misconduct. It felt surreal to be sitting in a criminal courtroom, describing how a dispute over generator extension cords had snowballed into criminal charges. Margaret's attorney tried to argue that the signature discrepancies were innocent mistakes and that the financial issues were bookkeeping errors, but the pattern was too clear. This was not sloppiness, it was intentional fraud. The case went to trial 9 months after Margaret's arrest. I attended several days of the proceedings, fascinated and horrified by the full scope of what she had done. Prosecutors presented evidence of 17 forged signatures, 14 instances of altered meeting minutes, and over $32,000 in misappropriated HOA funds over a 2-year period. The brother-in-law testified against her, admitting that Margaret had instructed him to inflate his invoices and that they had split the overcharges. He had taken a plea deal in exchange for his testimony. The jury deliberated for less than 4 hours. They found Margaret guilty on 3 counts of forgery and 2 counts of theft. Sentencing was scheduled for 6 weeks later. I was in the courtroom for sentencing. Margaret looked small and defeated, nothing like the imperious HOA president who had taped that first violation notice to my door. Her attorney pleaded for leniency, arguing that she had no prior criminal record and had already paid restitution to the HOA. Judge Walsh, the same judge who had presided over my civil case, was not sympathetic. "Mrs. Pemberton, you held a position of trust in your community. Your neighbors elected you to manage their shared resources and enforce rules fairly. Instead, you used that position to enrich yourself, to target people you disliked, and to forge official documents. Your actions went beyond simple abuse of authority. They were criminal." Margaret was sentenced to 2 years in prison, with the possibility of early release after 1 year with good behavior. She was also ordered to pay full restitution to the HOA for all misappropriated funds, totaling $32,000, plus court costs and fees. As the bailiff led Margaret away in handcuffs, I felt a strange mix of satisfaction and sadness. All of this because I had set up a generator with properly rated extension cords. All of this because one person had decided that her aesthetic preferences mattered more than following rules and treating people fairly. The HOA underwent significant changes in the aftermath. Linda Martinez became the new president and immediately implemented reforms. The board adopted clear, written criteria for violations, requiring that any cited violation be documented with photos, and that all similar violations in the neighborhood be cited within the same time period. They established a transparent approval process for all expenses over $500, requiring competitive bids for any service contracts. They created an independent appeals committee so that homeowners challenging violations would not have to appeal directly to the same board that issued them. The neighborhood itself changed too. The whole saga had brought people together in a way that normal community events never had. People started actually talking to their neighbors, organizing social gatherings, and taking an active interest in HOA governance. Board meetings went from having 5 or 6 attendees to regularly drawing 20 or more. As for me, I continued living in my house in Meadowbrook Hills. My generator and extension cords remained in my garage, properly rated and ready to use if needed. I had spent months of my life and thousands of dollars defending something that should never have been an issue in the first place, but at least the outcome made the neighborhood better for everyone. I ran into Todd Murphy, Margaret's former ally on the board, at the grocery store about a year after everything ended. He looked uncomfortable when he saw me but stopped to talk. "I owe you an apology," he said. "I went along with Margaret on a lot of things I should have questioned. I let her convince me that maintaining control was more important than being fair. I'm sorry." "I appreciate that," I said. "Why did you go along with her?" "Honestly, because she was forceful and confident and I was lazy. It was easier to just agree than to push back. I've learned a hard lesson about the importance of actually paying attention and thinking for yourself." Todd had resigned from the board after Margaret's removal, saying he did not feel worthy of the position anymore. I respected that self-awareness. Derek, my electrician friend who had started this whole thing with his professional assessment, thought the entire saga was hilarious. "You realize you've become a legend in electrician circles," he told me over beers one evening. "I tell this story at every conference I go to. The HOA that went to war over properly rated extension cords and ended up with their president in prison. I could have done without the legend status. Hey, at least you won. Most people just pay the fine and move on. I thought about it. It would have been cheaper and easier. But then Margaret would still be running that HOA into the ground, and she'd be targeting someone else now." He was right about that. Jennifer told me that several homeowners had approached her after Margaret's arrest to share their own stories of unfair treatment that they had never reported because they were afraid of retaliation. Margaret had created a culture of fear that had affected dozens of people over the years. My lawsuit and everything that followed had exposed that system and torn it down. Was it worth the stress and expense? Most days I thought so. The local newspaper ran a feature story about the whole situation, titled "HOA Horror Story, Ends in Prison Sentence for Former President." The reporter interviewed me, Linda, and several other homeowners. The story went viral on social media, getting picked up by news outlets across the country. Apparently, everyone loves a good HOA horror story, especially one with a clear villain and actual consequences. I got messages from people all over the country sharing their own HOA nightmares. Most of them did not have happy endings. Most people just paid unjust fines or lived with arbitrary rules because fighting back seemed impossible. I felt fortunate that Illinois had relatively strong homeowner protections, and that I had found a good attorney who was willing to take the case. Patricia Stevens, my attorney, ended up specializing in HOA law after my case. She told me that the publicity had brought her dozens of new clients dealing with similar issues. She was building a reputation as the attorney to call when your HOA was abusing its authority. "You started something," she told me. People are realizing they don't have to just accept whatever their HOA board decides. They have rights, and those rights matter. 2 years after the initial violation notice appeared on my door, life in Meadowbrook Hills was remarkably peaceful. The HOA functioned smoothly under Linda's leadership, enforcing rules fairly and transparently. Violations were rare and consistently applied. Community events were well attended. People actually seemed to enjoy living there instead of living in fear of the next arbitrary fine. I was elected to the HOA board myself, something I never would have imagined when I first moved in. I ran on a platform of transparency and fair enforcement, and won easily. Apparently, successfully suing the HOA and getting the president sent to prison gave me credibility. My first board meeting was surreal. I sat at that same folding table where Margaret had once presided, looking out at my neighbors, and thought about how much had changed. We discussed mundane things like pool maintenance schedules and landscaping contracts. No drama, no vindictiveness, just people working together to maintain their community. During the meeting, a new homeowner raised his hand with a question. "I just bought a house here last month, and I wanted to ask about backup generators. I'm thinking of getting one because of the power outages last winter. Are there any restrictions?" The room got quiet. Several people looked at me, suppressing smiles. I cleared my throat. Generators are allowed as long as they meet local building codes and electrical safety standards. If you want to install one, I'd recommend hiring a licensed electrician to help you set it up properly. The HOA has no additional restrictions beyond compliance with safety codes. That's it. That's the whole rule. That's it. Wow, that's reasonable. I was expecting some complicated approval process. "We try to keep things simple," Linda said. "As long as you're not creating a genuine safety hazard or nuisance and you're following applicable laws and codes, you're generally fine." After the meeting, several people came up to talk to me. Some thanked me for standing up to Margaret, saying they wished they had done it sooner. Others shared their relief at how much better the neighborhood felt without the constant fear of arbitrary enforcement. One man, an elderly resident named Frank, pulled me aside. "I've lived in this neighborhood for 15 years, longer than anyone else here. I watched Margaret turn this place from a friendly community into something that felt like a police state. What you did took courage, and it made a real difference. Thank you." That meant more to me than all the news articles and social media attention combined. I had not set out to be anyone's hero. I had just wanted to use my properly rated generator extension cords without being fined for it. But sometimes standing up for yourself ends up helping everyone around you. Margaret was released from prison after serving 13 months. I heard through the neighborhood grapevine that she had moved to another state to live with relatives. I hoped she had learned something from the experience, but I also hoped I never saw her again. The generator sat in my garage, a silent reminder of the most ridiculous fight of my life. I had used it exactly 3 times since that first power outage that started everything. Each time, I carefully ran my properly rated, outdoor-approved, 12-gauge extension cords from the garage to my house, powering my essential appliances exactly as intended. And each time, I thought about how something so simple and reasonable had nearly cost me hundreds of dollars and months of stress, and ultimately led to someone going to prison. It was absurd. It was infuriating. It was one of those situations that never should have happened, but spiraled out of control, because one person in a minor position of authority decided to abuse that power. I thought about all the other Margaret Pembertons out there, sitting on HOA boards and city councils and school boards, and anywhere else people could get a small taste of power over others. How many of them were issuing unjust fines, making arbitrary decisions and targeting people they did not like? How many people were just paying those fines and accepting that treatment because fighting back seemed too expensive or difficult? My case proved that sometimes fighting back works. Sometimes the system actually does what it is supposed to do, protecting people from abuses of authority and holding wrongdoers accountable. But it required resources, time, good legal help, and more than a little luck. If I had not found Patricia Stevens, if Jennifer had not kept her records, if Robert had not come forward, things might have ended very differently. I made it my mission on the HOA board to ensure that no one else would ever go through what I went through. We established clear guidelines for everything. We created multiple channels for homeowners to raise concerns. We made all financial records available for inspection by any resident. We required supermajority votes for any fine over $100. We implemented term limits so no one could entrench themselves in power for years the way Margaret had. Were we a perfect HOA? No, there is no such thing. But we were fair, transparent, and accountable. That was all anyone could really ask for. 3 years after that first orange violation notice appeared on my door, I was sitting on my back patio on a Saturday afternoon, grilling burgers and drinking a beer. Derek was there, along with a few other friends from the neighborhood. We were talking about nothing in particular, enjoying the warm summer weather. "Remember when you called me about that HOA fine?" Derek asked out of nowhere. "When you said you needed me to document your generator setup, how could I forget? Did you ever imagine it would turn into all of this?" I looked around at the friends I had made, the community that had come together, the positive changes that had resulted from months of stress and legal battles. Not in a million years. Would you do it again? Knowing what you know now, I thought about that question seriously. It had cost me time, money, and stress. It had dominated my life for months, but it had also exposed corruption, helped my neighbors, and ultimately made the community better. "Yeah," I said finally. "I would, because someone had to." Derek raised his beer bottle. To properly rated extension cords and the willingness to fight for what's right. We all clinked bottles and drank to that. As the sun set over Meadowbrook Hills that evening, casting golden light over the identical houses with their regulation mailboxes and carefully maintained lawns, I felt something I had not felt in a long time when looking at the neighborhood. Genuine contentment. This place was home now, not because it was perfect, but because we had fought to make it better. And in my garage, the generator sat ready, with its properly rated extension cords coiled neatly beside it, a monument to the most ridiculous and ultimately meaningful battle I had ever fought. All because Margaret Pemberton decided that her aesthetic preferences were more important than following the rules, and I decided that I was not going to let her get away with it. Sometimes the smallest things lead to the biggest changes. Sometimes a violation notice about extension cords can expose years of corruption and abuse. Sometimes standing up for yourself means standing up for everyone. And sometimes, just sometimes, justice actually prevails.